to aware the general people at large and to expand the process of mediation throughout the state of West Bengal and Andaman Nicobar Islands, we are now organizing a mediation fortnight in 2 phases. It is going on at all the district courts and subdivisional court levels. You please join there and assist us to augment the process of mediation in our state. We are now showing before you the message of the former Honorable the Chief Justice of the Calcutta High Court, Honorable Justice T B Radhakrishnan, about his concept or his thinking on the process of mediation. Please see.
It is said that the world is in a period of pandemic. Let me say that it is not a period of distress. It should be a period of rejuvenation, which will enliven the society to come forward and reach a better tomorrow. With such ideas in mind, we have been repeatedly hearing from different zones on easing the way of doing business, easing the doing of business. What is meant by business has to be understood in a very large content. It is not to be confined to the commercial activity of a particular place, group, region or nation, or even in the international domain. There is a business which is called the business of life, business of individual life, business of family life, business of commercial life, business of state life, business of national life, business of community life. Therefore, easing the doing of business is something which is to be understood in a larger perspective and in a manner which it can be carried forward to bring the real goals nearer for human excellence. Today I say this in the context of the need to focus on easing the business of judicial business and litigation handling business. That is also a business in the sense that it is also an activity. Easing the judicial business, easing the litigation handling business, easing the resolution business in litigations, easing the business of conflict resolution. These are ideas which needs to be focused with the change of times. If the corona pandemic has thrown up challenges, we should grow ourselves in such a way that the challenges have to be faced. There are different stakeholders in the system of what is called the alternative disputes resolution mechanisms, which has been devised not merely in India but in the international domain for inter-country resolution as also for resolution of disputes even among human beings in different nations. Modalities of alternative disputes resolutions are recognized insofar as India is concerned in the Code of Civil Procedure, in the commercial courts laws which have now come into place, and the modalities of family laws enforcement in India. We have also judicial pronouncements of the Apex Court, that is the Supreme Court of India, which have paved way to bring a tranquil atmosphere to resolve litigations which sometimes also move on to the criminal jurisdictions. The ultimate aim is to find out resolution of disputes, conflict resolution, and resultantly litigation resolution, which will pave way for better handling of the business of human life of community living and of the national life and international life as a whole. There are different stakeholders in a process which is called mediation, which is now the in thing and a flagship which is being carried forward through the different mediation centers throughout India and even abroad. Commercial mediation, mediation in non-commercial litigations, mediation in family litigations, mediation in other litigations including civil disputes, and various other modes are being resorted to. But the ease of doing the business of litigation resolution or conflict resolution through the mode of mediation would be best achieved only if all requisite entities involved in the process do their required input and apply it in a particular manner which suits every situation the best. Insofar as the judicial officers are concerned, we have a process of reference or a referral, that is referral to mediation. Law is by now quite certain and clear as to what cases can be referred for mediation, what cases cannot be referred for mediation. Every judicial officer throughout India is expected to know these principles and classifications in terms of the judicial pronouncements of the Hon'ble Supreme Court of India and guiding principles which have come through the Mediation and Conciliation Project Committee of the Hon'ble Supreme Court of India. With that, every judge dealing with every litigation, particularly in civil jurisdiction, should have a mindset to find out whether there is an element of settlement in a particular litigation. I am sure that every judicial officer who shows a little bit of painstaking work to read the pleadings, look at the basic issues and focus on the problems can necessarily know whether there is an element of settlement in a litigation. If that be so, that is the opportune time for that officer to do the needful to not only make a referral order and refer the case for mediation, but also to facilitate the mediation by making the initiation of the mindset of the people who are involved in the litigation and the learned advocates who are appearing for them to have a change in mindset and have a proactive approach to a mediation settlement through the process of mediation, which is an ADR mode or an alternative disputes resolution mode. The judicial officers will be doing human service to the society if they focus themselves and tune their mindset to ensure that mediation as a process of alternative disputes resolution is carried forward with the necessary thrust that they can put with the office that they hold. I am sure that the officers under the flagship of the High Court at Calcutta, particularly in the state of West Bengal and in the Union Territory of Andaman and Nicobar Islands, will focus on this and thereby uphold the actions and projects and processes being pushed forward through the Calcutta High Court and through the entire nation through the mediation process. All the best. Jai Hind.